Good morning, good afternoon, good evening, depending on your time zone. This is Biafra Radio, and we're reaching you out from United Kingdom. My name is still remember Mazi George's Chukume, and today is the D-Day. Today is the day we wish that the so-called Federal High Court led by Bin Tayako will redeem themselves from the judiciary of the zoo called Nigeria. Facebook, we do not owe any copyright on any music that we're playing on videos or to make any resource out of it. Please allow us to use those videos and audios to entertain Biafrans for today. Our leader is going to be appearing once again in Federal High Court. And I'm going to put the intro. Today, I'm not going to be putting my face up in the camera tonight. Today is going to be just the audio broadcast and the live coverage from our men on the ground and those that are going to be interviewed today. And today is the 20th day, year of our Lord, May 2024. And it's approximately 12 minutes on top of 12 minutes PM here in United Kingdom, the same 12 minutes on top of our 12 minutes past 12 PM in Holy Land of Biafra. And we'll welcome you on Biafra Radio. Stay tuned, please.
For Biafra must be restored, for there is nothing the enemies can do about it. We have come that the will of the Most High may prevail. Radio Biafra is unorthodox. The way we do things are markedly different from how others do it. We are under divine instruction. We have come that Chukwokika Biama may take control of these very proceedings this evening, for we are nothing without him. O Elohim, Chukwokika Biama Purimi Henine, unto thee we repose all that we are. Do not allow your children IPOB to be put to shame. Do not allow us to be devoured by the hands of the wicked. Do not allow us, O mighty one, to fall prey to those who do not know thee. You will deliver us, not because we are righteous, but because of your mercy. Hear our cry and our supplication. We are not armed. We have not killed anyone. We have not jailed anyone. We have not done anything at all to warrant the level of destruction and carnage being visited upon your children. The same way Israel suffered, so is Biafra suffering today. And if you, Elohim, can deliver Israel, so will you deliver Biafra. That is our hope. That is our anchor of everything that we hold dear as a race and as a people. You brought Biafra that light may come into Africa. You gave us hope because we are in a continent of hopelessness. And by thy grace, Biafra shall be restored. We shall be resurrected. We shall crown our efforts with the glory by the grace of the Most High himself. We are not strong. We do not pretend to be strong. All we do is to submit ourselves to your will, that your will may be done upon our lives. We have lost many people. We have lost so many good people. Their sacrifice will never be forgotten. We shall honor them, and for their sake Biafra will come. Israel lost people, and today Israel is here as a beacon of hope in a land filled with darkness. We beseech thee, O Elohim, because we are wandering all over the world hoping against every hope that things will turn around for the better. It has never turned around for the better. Instead, it is getting worse. Please do not abandon your children. You have given us a commission, and we must accomplish it in our lifetime. We have come to honor your holy name. We have come to praise thee. We have come to honor thee, that your name may be glorified, adored, and praised forever and ever. Ise. Without
Nande Kano Odogundi Mozi na Baloko. Obinigwe na-ekwu okwu ogwelibe gbalụ Jehova ya lee Obinigwe na-ekwu okwu ọ ka na-ekwu okwu Obinigwe na-ekwusi okwu ike Nnamdi Kanu Odogwu Bili.
Good afternoon from London here, fellow comrades and the regrettable. We are not in our Biafra Radio app. There's a technical issue there for those that might be thinking that try to use that platform. Regrettable, this afternoon, we are not able to connect to Biafra app radio. Please follow us in the other pages, Biafra Radio, Alpha Power Media, and UK, and all the YouTube pages as well, as we'll be bringing you the update from Federal High Court Abuja on Spot account this afternoon. And I'm still here in UK in the London studio, and we'll welcome you in Biafra Radio. So we continue to be playing some previous videos, appearances of our lead counsels. Firstly, I'm definitely going to play after this music. I'm going to go through Shore and do some analysis on that before we move forward. But before then, probably I'm going to bring the man on the ground to give us on-spot account on what is going on there at this point in time before we proceed, please.
Nnamdi Kanu Ọchịagha ụmụ Igbo Odogwu Biafra Bili Odogwu ndị Mozi na-agbala ọkụ. Eziokwu na-enu wee sikanụ n'enu ụwa n'osi na chi ya dị mma. Mgbe mbụ ka sị na Nweze enwelo nwa, mana tata na Nweze enwegokwa nwa. Mgbe mbụ ka sị na Igbo enwela eze, mana tata na anyị bụ Igbo anyị enweghị ezenu. Nnamdi bụ ya bụ eze ndị Igbo. Eziokwu na-enu ụwa ebuka, eziokwu na-enu ụwa siri ikenu, eziokwu na-enu ụwa esikanụ. Ọkwa ịma na onye na-achọ onye aka ya dị ọcha na ọchụgide onye n'enu ụwa chụbịa n'ụwa ọmanụ. O ji be nwata wonye aka ihe nu akalobe ya ilo n'oge wetu ya n'enu ụwa nụ. Ife Nnamdi na-ekwu n'enu ụwa nụ n'ọbụka oge si dịlị n'ụmụ Igbo mmanụ. Titi eji wee nwee Naijiria na ndị Igbo n'enu ụwa na pachibelo Naijiria. Ife a na-eme anyị bụ getaway come closer. Onye ọbụla n'enu ụwa na-atụ alele. Ili niile n'ụwa bụ ọlụ. Onye Igbo ịchọ ọchịchị na ọ bụ ọlụ nụ. gwa m ife ga-eme n'ụwa ka emezie n'ụwa wee metụ ụwa mma. N'ọkwa bụ ndị Igbo bụ nsogbu anyị nwelu na anyị bụ ndị Igbo na anyị na-agbazi onwe anyị mgba. Gwa m ife ga-eme metụ ụwa mmanụ, gwazie m ife ga-eme wee metụ ụwa mma. Nnamdị na o nwere okwu nchọla ịgwa anyị, ichefugo na nwaeze adefu na mbanụ, n'ọkwa na nwaeze ka ịbụnụ, maka na ama m n'ọchịchị lụrụ ibe nna ya. Iwere pụ ọchịchị lụrụ ibe nna ya, iwe pụta ka ịzọpụta ụmụ Igbo nụ. Ụmụ Igbo afọ na ị ga-azọpụta fa, eziokwu na o nwere ife ga-eme gị n'ụwa. Ị ga-adị ka echi, maka na ama m na echi n'ọdụ agwụ agwụ. Ndụ gị ga-adị n'afịa naanị izu na anọ, eke na orie na afọ na nkwọ ka ndụ gị ga-adị nụ. Onye chụba gị na ọ ga-ada mmiri, ọtụ nwa ọkụkọ nne n'ụwa ya nwada. Nwa ọkụkọ nne n'ụwa nwee ngwongwo ọsọ. Nnamdị na mmeli bụ nke anyị. Ome mma melu gaba n'ilu, ome njọ melu n'ụwa gaba n'ilu. Agbasa ọsọ nne n'ụwa na-aga agụlili maịlụ, maka na emesịa nne n'ụwa malụ ndị bụ ndị. Aka Chukwu na ọ dị gị n'alụ, Nwachukwu na mmesịa mmeli bụ nke anyị. Nnamdị Kanụ odogwu bili, eze ndị Igbo gburugburu. Chukwu ka na-ekwu okwu, Obinigwe na-ekwu okwu, ogwelife gbalụ Jehova ya lee. Obinigwe na-ekwu okwu, ọ ka na-ekwu okwu, Obinigwe na-ekwuzi okwu ike. Nnamdị Kanụ ọchịagha ụmụ Igbo, odogwu Biafra bili, odogwu ndị Mazi na-agbala ọkụ. Sumudu eziokwu na alịlị na-egbu m, ụmụnne m na alịlị na-apịawa Mazzi. Onye Igbo wee gụsị akwụkwọ nụ na inweta ọlụ na Naịjirịa na ọbụzi ọlụnụ. Na anya pasi lọ ife ọbụla na ịlụ naanị na Naịjirịa na ọbụzi nsogbu. Ịlụ na polisi bụ ọlụ, inye ndị Igbo ọlụ n'ọkwa nsogbu. Gwa m ibe a ga-eme n'ụwa ka wee metanụ ndị Naịjirịa mmanụ. Ife anyị nwee ka na-akọla anyị na mmanụ anyị ka Naịjirịa ji dị ebube. Mineral and resources anyị nwelu n'ụwa nọ ya ka Naịjirịa si wee dị ebube. Ma ndị nwe ife na-aga ụlọ na-emelụ falụ, ndị nwe ife na-aga ụlọ na-apịawa fazụ. Chukwu ka na-ekwuriri okwu nụ, ndị eluigwe ka na-ekwu okwu nụ. Basi na-emesịa na anyị ga-enwe mmeli nụ, na-emesịa na n'ụwa na mmeli bụ nke anyị nụ. N'ote ga ka ọ dị njọ n'ụwa, na-emesịa na n'ụwa na-emesịa na ọ ga-adị mma nụ. Ọkwe mana Chukwu ka na-ekwu okwu nụ, ndị n'igwe bụ aka na-ekwu okwu nụ. Icheta ife melu n'oge gara aga mgbe a nụrụ Naịjirịa Biafra wọ, bajidelu ndị be anyị nụ, wee sụọ ndị be anyị ka akwụ n'ọkwa nne n'ụwa. Eziokwu na alịlị na-egbu mụnụ, ngekwuzi one ya libi ya nụ. Obinigwe ka na-ekwu okwu nụ, mmeli na bụ nke anyị. Sumudu alịlị onye na-epe ibe kata ibedebe, etela ugbo etela ose, ya emesikwa na ọ ga-adị mma. Maka na mụ ma na ikuku bugharịsị ọdụ igwu, ọ ga-akwụbi ofu ebe. Sumudu Chukwu ka na-ekwu okwu, Obinigwe na-amụ anya, n'aka Chukwu dị n'alụ anyị. Ụmụ Igbo Chukwu ka na-ekwu okwu asị miracle coming on the way na o nwere ibe walụ Jehova ya lee Chimo Nnamdị na Chukwu na-ekwu okwu Nnamdị Kanụ odogwu ndị Mozi na-agbala ọkụ Nnamdị Kanụ.
Yeah, this is still Biafra Radio. And today is the 28th of May 2024. And the proceeding is going to be taken on in Federal High Court. But I'm still waiting on the men on the ground, those that are there to give us the feedback, what's going on there. Like I likely said this afternoon, I won't be on the screen, but you'll be hearing my voice. I'm going to do voice this afternoon for this proceeding. But I'll be playing a couple of videos as well. So I'm going to do some analysis this morning. Just a reminder, recaps on what have transpired. Firstly, I think Shaw already said something that, we all of us agree. And it's up to Binta and Yako this morning.
Nnamdi Kanu is being held hostage.
To do herself a service, because we know that this is a political motivated, but they can't hold our leader forever. Mandela spent 27 years in prison. And at the end of that journey, his people got what they wanted. And we are on that path. Our own is not going to be different. And good thing about this whole thing is that our leader was willingly to face this battle, carry this cross alone. And all of us must do our part. Like he said, he will not disappoint us. We are the ones that are going to disappoint him. And he's playing in today. So let's listen to Shore. And this is a reminder, because today is a very significant day in the life of the Nigerians. And Binta Yako in particular will not trade Mazi Kanu for his own dirt. His family has been, involved in financial crime in that contraption called Nigeria. But our leader will not be what she's going to use to bargain. That is not going to happen. And we all understood who is the engineer of all the things that we are facing. Britain is involved because our leader is carrying British passport, but they keep deaf ears that they don't know what is happening. And I rightly said, he said they're holding our leader hostage. It is not the zoo. The Britain is the primary suspect in this whole thing. And all the whole gag order and what happened in Kenya, but our leader willingly want to be in this position. And it's up to me and you to do our part. Let's listen to Shore, and I got a couple of videos I'm going to be playing while we are waiting on an on-spot account live from Abuja Federal High Court. I think they're still waiting for Binta Nyaku to appear in her court. I don't think she's going to run away. Our legal counsels are ready, and there's a picture already on social media. They are quietly waiting for her to show up, because this is a D-Day, and today she needs to actually listen to the Supreme Court saying that her act was irresponsible by revoking our leader's bail. Onyendu cannot face trial in DSS dungeon. Or we are saying that he cannot be in that position to face trial. Listen to the higher court of the land that passed the decision that you guys are into. You must obey what they have said. And at the end of that, then we can proceed. We can proceed. Our leader said he's not scared of, standing and face the trial if you have anything to try him on. But we see how that pans out. But what we are saying is that they must listen to their own ruling. Their own judiciary must be respected if they have any dignity, and the world is watching. So, like I said, let's listen to this short clip, and we continue.
On behalf of the famed unity of Nigeria. That's what it's all about. It's as simple as that. If you mention his name in certain circles, they don't want to hear it because they feel like he threatens the real estate called Nigeria. And his Igbo makes it worse because Nigeria's DNA hates the Igbo for attempting, in the 60s and, towards the end of the 70s, to leave a country they said is no longer favorable to their existence. But I keep saying, and I will repeat here again, is there any Nigerian out there in their majority who has not mentally seceded from Nigeria? Not many. That's why people are leaving in droves. Each time you get on a plane leaving this country is full. Each time it's coming back, probably full too. But it is those who are coming back to pack their things that are coming back. That's the way I describe it. But the truth is that Nnamdi Kanu has been held hostage. He was abducted from Kenya.
Lawman, can you hear me? Lawman, can you hear me?
Thank you very much, Mazzi, for bringing us in. You're reporting live from Abuja.
Thank you.
Although the afternoon is not very good here in Abuja, but we must proceed. We have commenced. The court has commenced proceedings a couple of minutes ago, and the business of today. Applications our defense team submitted, courtesy of Barrister Lloyd Jimako, which include providence of custodial arrangement for the defendant, Nnamdi Kanu, and the second one includes bail application. So the business of today is to give rulings to that effect. And right now, as I said, the court proceedings have commenced, and the judge stated clearly that the court would not grant Mazi Nnamdi Kanu bail owing to what happened the previous time. In their words, that Mazi Nnamdi Kanu did jump bail. And on the other hand, on the providence of custodial arrangement, the presiding justice, Bintanyako, ordered the DSS to provide somewhere where the defendant could meet with his lawyers, that is devoid of, bugging devices, microphone and cameras and what have you. So that is the situation report at the moment. But we are having arguments and counter arguments from the prosecution. The prosecution is stating that since the court has given its ruling to that effect, that trial, the substantive trial should commence. But our defense team is countering that the DSS would not, from all indications from what had happened in the past up until now, would not heed to the ruling of providing a safe and a safe environment where they would have pre-trial conferences. So that is the situation report, and seemingly the effect and the ruling of the Supreme Court is not heeded to. Let's see how it goes, because we have yet to arrive at the logical conclusion of today's business. So Mazzi, Umeh, and lovers of freedom listening and watching all over the world, that's the situation report today, dated 20th of May, 2024.
Yeah, Mazi, thank you very much, Mazi, Lawman. It's a kind of depressing hearing what you just said. Bintanyaku, I was just talking about this before you get online, and she's still insisting. And how could she be the one? She's the judge, and giving the DSS, they're actually prosecuting our leader to give him. How is he going to? There's no way they can give our leader any place that is safe without bar. Everybody knows that. So it's practically impossible. So I don't think they want this trial to commence. So that means the delay tactics is what they're playing on, and the whole world is watching. And the capital is that she did not adhere, like you rightly said, the judgment of the Supreme Court, which is the supreme of the land, the law of the land, the highest law of the land, past order, and the lower court now, refuse to adhere to it. And it's quite disheartening. And that has showed us that something is not right, to be fair. But the world is watching, like you said. We will keep on here still trying to analyze things as you have given us the preview and background of what is going on in there. I will still hold on to see how everything, comes out at the end of the day. Thank you, Mazi Lawman, for your tenacity and for giving us this insight now. But to be honest with you, I'm kind of disappointed. That's all I have to say. Thank you very much, Mazi Lawman.
Yes, before you go, the basis of our application, the defense team in question, is standing. It has a local standing on Section 287 of Nigeria's constitution, as amended, as they say it. I quote: "The decisions of the Supreme Court shall be enforced in any part of the federation by all authorities and persons, and by courts." You know, I underline that very court, and by courts with subordinate jurisdiction to that of the Supreme Court. End of quote. You see, by courts subordinate to this said apex courts, the Supreme Court includes customary courts, state high courts, and federal high courts. And you know, I don't need to explain further. It is self-explanatory what is playing out, that the federal high court is playing insubordinate to which courts they should respect. And what are we trying to say? The Supreme Court says Nnamdi Kano's bail was erroneously, you know, revoked. So let's see how it goes. And I know our defense team, they have the ingredients, they have the wherewithal to argue without. Let's see how it goes. Hopefully, we shall see to it. You know, thank you once again, Mazi. Umeh.
Thank you, and stay put. Yeah, thank you. Whenever they will just indicate, you know, thank you very much. Thank you.
Rendition. The fact that
the truth about the matter is, like, we continue. Everybody have heard what our man on the ground, lawman, reporting live from Abuja, that Binta Nyako is purely insubordinate to the Supreme Court, which everybody knows that the law does not apply in the zoo. And they come to the case of Biafra and our leader. It is quite a peculiar one because the whole world knew what happened and what is still happening. Britain is quiet, so it is orchestrated plan that they know what they are doing. They will try just like to hold our leader hostage. For how long to break him? That isn't going to happen. There is no way DSS are going to be the one to provide a safe place for our leader, because there in DSS dungeon, every place is bold. We know that, but at this point in time, they want to start trial. Our leader deserves his fundamental right to have a safe place that he can actually sit down with his legal team to strategize how they're going to defend themselves from the gag orders. All the falsified, they don't have any evidence, they will bring it forth and the whole world will see. Our leader have not committed any crime known to man. His fundamental right was trampled upon by kidnapping in Kenya and extraordinary rendition back to the zoo. And top of that, what happened that Onyin never jumped bail was on the 2017, to be precise. Onyendu was ready to go to court with over 1 million men. What did the Nigerian government do? They arranged their men with 1 battalion to come to Afari Quebec and murdered over 28 men, including Jack. And our leader escaped for his dear life. That is not what he calls someone jumping bail, because they came to kill him. And no one was wholly responsible for this hideous act. Until today, Binta Nyako is obviously playing in gallery because he's playing a sudden death based on what has happened. His family have soiled their hand, but Mazi Nnamdi Kanu and Biafra at large will not be a scapegoat for her. At the end of this journey, one thing is certain, as our leader said, that is either Biafra flag his ways or his lower sensitivity. At the end of the day, he's going to come out victoriously. And we shall, giving that a date for the referendum for Biafra to be decide if they want to be the part of zoo or not. And as we go forward, let's still continue listening to this audio until our man on the ground come back to us. Then we'll bring it to you, and the whole world shall hear him.
His kidnap from Kenya could not be explained. Shows that any judicial pronouncement or processes after that is null and void. You cannot go and kidnap somebody and bring them before a court. And the courts have made it very clear. Well,
as you can see, Showry just said everything. He's analyzing it properly. From day one, even our legal counsel said it. It's a trial within trial. That's nothing. They know there's no case. Because if Binta Nyako was actually following the due process, she knows that the crime has been committed. which he has attended to, which the Supreme Court have already pronounced that it was irresponsible. Everybody, every Dick and Harry should understand. It's rudimentary. It's not something that even a deaf and blind man can understand it. If they actually explain it to them, depends on how you communicate with them. But it is quite. Anyway, let's continue. But I mean, how long are they going to do this? To break him? Mandela spent 27 years, they couldn't. So why do they think this is going to happen now?
To the Supreme Court that he did not jump bail. It was the military that went to his house to kill people, and then he escaped. And now you have brought him back. You ought to respect and restore his bail. That's what I told his lawyers. Why are you applying for bail again? Because the Supreme Court made all the pronouncements except releasing him. And I think it was because they were afraid. And that's why I say he's a hostage to this country. And like you rightly said, there are other people who have made even more egregious pronouncements and fought and carried arms in this country. And
yeah, and what we are getting, Vin Tayaku said, if we have issues with my ruling, appeal. So this is a delay tactic. Appeal, what are we appealing? What is exactly what are we appealing? You know, it's quite, it doesn't really make any sense. That is the indication that we are getting. Bin Tayaku outrightly said that if you have problem with my ruling, she's quite irresponsible. To be fair, I don't know. And like I likely heard her from the previous, quote when she was actually making statement, because we never had her make statement before, So I think it's wise now that it was streamed that will actually catch her voice and the way she talk. And on top of that, she questioned people that are questioning her. When the lead counsel and the lead team are now cross-examining, and she doesn't like it. And she wants people to go through to actually follow the due process. But you are breaking the law. You sat down on that dock there doing something that is illegal. You aided and abetted a man that will kidnap an extraordinary rendition of his own. Is a crime. Even your own law is against your own law. And you allow that to happen. How long will you guys play this game? How long? How long is it going to go on? So we are still waiting to see what is coming out of there. But as it stands right now, it's a mixed feeling that we are getting because, how long are they going to do this? How long are they going to do this? That's the question. How long are they going to do this? Let's play some couple videos, and as we're waiting,
we were able to avoid the situation that if it had happened in court today, it would have been a deviation from Section 36 of the Constitution, which guaranteed every Nigerian the right to fair trial. The prosecution was forcing a situation on the court today that trial should continue or should proceed today. But our position was this, which comports with the law, that we have not had any opportunity. We have made this very clear. It is not about having access to our client. We do have access, but our access is monitored, hampered to the point that we are unable to discuss with him within that zone of confidentiality that is guaranteed between a lawyer and his client, and that enhances the defense we shall prepare to properly defend him against charges that carry the death penalty. So our position comports with the law, with Section 36 of the Constitution, that unless fair hearing can be guaranteed, no Nigerian can be subjected to any trial. You can check it out. We are not making it up.
Like I said, lastly, I'm trying to me, the court will interpret one way or another.
and if we pay attention, this is the previous interview on the last court appearance, and the same thing is still playing in. That nothing has changed. So obviously, everybody know that this is a delay tactics and it's not working. So they need to strategize, and because how long what trial do you want to? There's no way you can try a man that being held in a central confinement. Even someone that facing a death row, a death row still have a conducive environment, at least to able to speak to their lawyers, if they could find a way that something they hasn't said before. So I don't understand why they run away from their own shadows. right? They're giving you guys to give house arrest. Get a house arrest, because the house arrest could be. This is what the Soludo said, and a lot of people was jumping in Soludo's throat. Soludo said, "Hand over Mazi Nnamdi to me, to State House, okay? Anytime you want him out, because if he was there, then his lawyers will go there. It is quite easy. That somebody that is a governor that have given you that opportunity, to release Mazi Nnamdi as he may, he's not going to Afaruku Ibek. Let him now be in custody of Governor Chukuma Soludo as he ultimately offered. But they refused to do that. I'm playing this hide and seek. For me, this is a pure hide and seek game. Britain is buying time because they realize support, including the zoo itself. But like I said, the same interview and what we have just get from Lawman, our reporter from here in Abuja, is the same thing. And Binta Eko is just like goes on. If you don't like Marurum, reappeal. How many times are we going to be appealing? That something has to be done. For how long? Isn't their constitution? They don't obey their own law. You're insubordinate to your Supreme Court. That shows that. That's the reason why we want Biafra, because nothing works. Nothing works.
Let's presume. Are you ready for any eventualities if it doesn't go the way you want, or do we wait for the court to go?
Well, the attitude of a very good defense counsel is to cross the bridge when it gets to it. So we're not going to speculate. We're not going to preempt the court. We trust that the court will do the right thing when we come back by 28th May. If it doesn't, then we cross that bridge.
Thank you very much.
Thank you.
Fortunately, he didn't give a ruling, or she didn't give a ruling. I think they are referred to here, whatever. So let us wait on the 20th. If she makes a ruling, one way or the other, wherever they stand, then we can take the battle from there.
For some people are saying that yes, political solution could be a way out of this situation. What do you think about this?
I will not comment on that. Whatever I'm involved in that is very serious underground, I will not comment on that. I support them in what they are doing. If there are things we're also doing some other places, we'll continue doing it. But I can tell you by the grace of God, Nnamdi will not stay in this prison in the next 2 or 3 months. Or else I'm not part of this country. I can tell you that by His grace.
We appreciate it. Thank God.
Thank you very much.
What happened in court today. We do not want to call it a travesty of justice because of the respect we had for the judiciary, but we are utterly disappointed that today bail was refused. On what grounds? The Supreme Court on 15 December criticized very severely the revocation of Mazi Nnamdi Kanu's bail in several pages, which we are going to make available to the media. At pages 19, 20, and 21 of Justice Agem's judgment, he even suggested that the impartiality of the trial court in revoking Nnamdi Kanu's bail is suspect. We didn't mind all of that, but see, we made an application, a fresh application, to my Lord, urging her to exercise discretion to restore Nnamdi Kanu's bail. She refused it without any reason whatsoever. And then we made a second application to accentuate the need for this bail application, pointing to the enormous challenges we face as defense counsel in consulting with Nnamdi Kanu privately and confidentially at the detention facility of the DSS headquarters in Abuja. We are only allowed 30 minutes each as counsel on only Mondays and Thursdays for a cumulative period of 2 hours, twice a week, to consult with him separately. And the federal government is feasting to have an accelerated trial. Yes, we too want an accelerated trial, but we have to have it under an environment that respects Section 36, Sub 6, B and C of the Nigerian Constitution. It's all about fair hearing. It goes to the ground norm. It goes to the basic norms of the society that you must hear the other side. And to hear the other side, he has to have an adequate facility to prepare his defense and to consult with his lawyers. It's the Constitution that said it. It's not us that said it. So we came to my Lord with an application and said, listen, it's impossible for us to conduct this trial under this atmosphere of interference with his right to counsel. They eavesdrop on our conversations. In the little cubicle room of 10 by 10 where we consult with Mazi and Namdekano. They have secret listening devices and secret photographic and videographic devices. They listen to our conversations secretly. They take our secret photographs. And we adduce this evidence before my Lord. They confiscate our legal documents. They don't allow us to take notes. Pray. You may be lay men and lay women. The general public may not be lawyers. But is this fair? How can you have trial under circumstances like this? It's not possible. So we are not stalling. It is the federal government that is stalling. We can't take notes. So what is the essence of it? We cannot prepare him adequately. We cannot talk with him. We whisper. We put our lips to his ear. We talk sotto voce. And so on and so forth. So this is the essence. This is what happened in court today, where justice was turned upside down when our 2 applications that go to fair hearing were refused. But we are going to bounce back. There are more applications to come.
Are you going to appeal on this ground?
Yeah, definitely. Appeal is ongoing as I speak. Today, by tomorrow, appeal is filed.
Okay, excuse me. Please, in addition to that, yes. Please. Yes. In addition to that, what happened today is an act of Federal High Court overruling the decision of a Supreme Court. I want you to get it right. Because the Supreme Court said, Nnamdi Kanu never jumped bail, that the court ought not have revoked that bail on the application of the violator of his right, that is the federal government. You cannot benefit from your own wrong. And we thought that the Supreme Court would have exercised its power under Section 6 of the Constitution to make a consequential order directing that Nnamdi Kanu should be released. But they directed that the trial should be continued here, and we should make an application. Of course, we ought not have made any application. Court should have exercised his power discretionary and released Nnamdi Kanu. That they never did. Then, secondly, which is the most fundamental, I had been going there to visit Nnamdi Kanu. They never allowed me to exercise my right as counsel to Nnamdi Kanu. And my right was violated. I took DSSS to Federal High Court. Federal High Court warned DSSS, ordered them to apologize to me, and ordered that they should pay me 5 million naira for close to 2 years now. They have not paid that money, and though I just allow it, that's why I have not enforced it, because 70% is running on top of it. Nobody has appealed against it. So now we filed the same application before the court. It's in the court file, asking my Lord to prove that we are not free. Where court has even taken judicial notice of that, but all to no avail. Now the court said that we should apply, since we cannot transfer Nnamdi Kanu to Kuje prison, stating that there is no security at Kuje prison. So that we are now applying that Nnamdi Kanu should be detained, should be remanded in a private house. And we are suggesting Abia State Government House or Abia State Liaison Office. So that is the application. So that is it.
Wait. I want to thank the press, for keeping the struggle alive. Yes. Now, I must tell us something. What happened today in this court is almost like an opportunity lost to bring peace, immediate peace, to the southeast. The Supreme Court had given the Federal High Court the opportunity to bring peace to the southeast. And they lost it. Unfortunately, they are toying with that opportunity given to them by the Supreme Court. All that the Federal High Court need was to go back to the ruling of the Supreme Court and follow it and give back the bill it had previously withdrawn. And then you will see absolute peace in the southeast. But with what happened today, it's obvious that certain persons don't want that peace to return to the southeast. And we are imploring members of the public to please continue to interrogate the reason why the Supreme Court judgment of 15 December 2023 will not be complied with by a Federal High Court. Yes. We need a Federal High Court to simply obey the orders of the Superior Court. A court, look, you did not employ the judges of the Supreme Court for the sake of employing them. Whatever word they utter from their mouth
touches on something fundamental. And in this case, in other circumstance, what is fundamental is Nnamdi Kanu did not jump bail. You have no reason to have revoked his bail. Restore it. And the Federal High Court is kind of toying and playing around with it, thereby continuing to create the chaos in the southeast, thereby continue to make the federal government waste money. Do you know how much the federal government is spending every day now? The Kanu case coming. They told us they spend 500 million naira. Somebody is signing off that check. Somebody is signing it off. Who is signing off? Who is making money from it? Extra allowances are being paid to all the security men who are in Abuja because of Nnamdi Kanu. It's your money. And we have been saying the case of Nnamdi Kanu is not such that we need to spend scarce resources on. The federal government is caring about money. They don't have money, but they have all the money to pay all the security agencies. If you go outside, not less than 1,000 security agencies are on patrol in Abuja because of one single man. And tomorrow they will tell us they don't have money to pay salary of workers. So we need them to be reasonable. We need them to do the right thing. We need them to do the proper thing. Thank you very much.
Nnamdi n'ọbụ ndị Igbo leliyele wee nwụrụ iwe nwunye ndị ilo n'aka emesịa na ọ ga-adị mma nụ maka na o chetalụ m ife melu n'akwụkwọ nsọ mgbe Josef na-akwanite mgbe ọ na-achị ichi eze ụmụnne ya jikọtala aka wele ya welesi ya ndị ilo mana Josef mesili wee bụla eze Joseph no mesiri bụla eze Nnamdi n'ọbụ ife ga-eme afụlụ m amụma ka ọ na-abịa na mmezu cheta tupu ndị lebulu yi amụma niile ibusili ọbịazigo na mmezu emesianụ na ọ ga-adị mma onye na-ebe akwa bedebe onye na-erujuru debe maka na afọ m na mmeli na njedebe Ezekwu na mmeri ga-abịa n'ikpeazụ onye na-ebe akwa bedebe onye na-ekpe ekpele kpesibe ike onye na-eme omenala emesibe ike nụ eziokwu na ndị Igbo anwago without ndị Igbo there is nothing like Nigeria.
I'm not relaxed until we get absolute and total victory. I'm not relaxed. We know the law. My team here, they are more than perfect. They know what to do, and they're going to do it. And we're going to prevail ultimately. Because justice must prevail.
He's still in the dock.
The court also...
We'll give you a woman from Southeast.
Depending on the strength of the argument. They're using it to do experiment at DSSS. Exactly. I don't see it. There is no way we're going to allow that to happen. My rights must be respected. Yes. My right to fair hearing must be observed.
There's nothing to Kenya into this dock and allow him to talk without his lawyer.
And he's only fighting for justice. Yes. I have congenital heart failure. Congestive heart failure is called. From the medication, you can tell. So they're basically trying to keep me alive. So when they calculate that I'm about to give up, that my heart's about to pack up, they will now say go. So when I go outside, I will die outside. That's what they're trying to do.
The medications they've been giving to you,
yes.
It's
not working. If it's working, why would I have all these lumps underneath my...
And he has written a petition to the Nigerian Medical Association where they brought one quack doctor, somebody who is not a doctor, to treat him.
To come and try and treat him.
But up to now, they have nobody.
They don't know what they're doing. And they know they don't know what they're doing. Or else, why would I have this?
As long as it remains in DSS custody,
there will be no trial.
He's seeking for a non-custodial arrangement by the court. Because, exactly, I don't mind house arrest. Because I'll defeat them. In this court, I'll defeat the federal government of Nigeria. Yeah, the whole world will see it. Where is the feasible felon? Where is it? All these years, journalists are having feasible treason. What is treason today? It's gone. In some way, this terrorism charge will go. I'm thinking of another capital offense that can charge me. Maybe, I don't know, impregnating the wife of somebody. I don't know. The federal government, they know I'm not guilty. My only guilt is that I'm fighting for my people. And I will fight for it. For justice. For justice and fairness and equity everywhere.
Advice to the people of those who are using IPOB to commit crime.
Using IPOB to commit crime is a criminal. Yes. It's not part of this family.
Repeat it again.
Our family is based on 4 cardinal points. You must be without fear before your enemies. You must speak the truth always, even if it leads to your death. You must help the poor and those who cannot help themselves, and be of good character that God may love thee. That's who we are.
So what will be your words to those out there in the East who are killing your name?
That they are criminals. They are criminals. They are not part of this family. We are called a family for a reason. We've come to serve our people, not to enslave them. Anybody conducting any type of activity that contravenes the welfare of our people is a criminal. I must be dealt with.
Wait, when you repeat this one.
Anybody.
Quite interesting thing here. There's something I'm doing up here. Binta Nyaku said I will personally write the ruling to the deliver to DSS for safe place to be created for MMK to meet with his team of lawyer Binta Yako. It is quite bizarre that Binta Yako think that DSS will respect her of her writing to DSS. Why she did not respect the Supreme Court judgment? It is quite it's unfathomable. So it is they're playing ping pong to themselves. You know, they're contradicting themselves. I don't know how long they're gonna go on this. Like I said, I don't know how long this is going to go on. Right? Like we're still here in the studio waiting from our man on the ground on spot account to give us what is still happening there. But I'm just reading up what's some bulletins that I'm being sent here. So Binta Yaku want DSS to respect her ruling by written directly to them, but she failed to listen to the rulings of the Supreme Court of the land. Is it that a charade? We are watching. At the end of, I saw our leader, there's a video, our leader herself was in the door questioning Binta Yaku. So let's continue watching because a lot is going to happen now.
Who is involved in any form of criminality, any form of violence or subversion in the name of Biafra is not part of this family. Our family is noble. It's called IPOB. It's all over the world.
So you condemn anything that has to do with killing in the southeast?
Why would I kill violence? People have sacrificed my parents for them. Why would I want to kill any other person after that?
April 18th, 2024. From ALOY Edgemaker. TO. All Media. Corrigendum. Mazzi Nnamdi Kanu never gave any conditions for his trial as some media outlets had reported. My attention has been drawn to some publications in the media purporting that, at the last hearing of his case on April 17, 2024, Mazzi Nnamdi Kanu had given conditions for his trial. By this press release, I wish to make it clear that any such publication, regardless of how well-intentioned, is misleading. For avoidance of doubt, below is the true state of affairs. 1. At the last hearing in April 17, 2024, the main issue before the court is our application to have Kanu's bail reinstated, in line with the clear and unequivocal pronouncement of the Supreme Court in its judgment of December 15, 2023. 2. The kernel of our argument for bail restoration pivots on the determination made by the Supreme Court to the effect that Kanu's bail was revoked in error, based on the misrepresentation or false premise that he had jumped bail, of which the Supreme Court made a finding that he did not. Below is part of what the Supreme Court had stated. See pages 10 to 13 of the judgment attached to this press release. The respondent was on bail and therefore in custody of the law when his home was illegally invaded by heavily armed military officers of the appellant, causing him to flee from his home and the country to secure his life. In the face of such an attack, it was responsible for him to flee to secure his life and physical well-being. That is what any normal and reasonable human being would do in that circumstance to preserve his life and physical well-being. It is glaring that the consequences of that attack were intended or foreseeable. This is not arguable. The appellant's officials knew that their invasion of the respondent's home caused him to turn away to secure his life and physical well-being. Yet during proceedings in the pending criminal case against him, they applied that his bail be revoked, that a warrant for his arrest be issued and his sureties forfeit their respective bail bond, and that his trial in his absence be ordered because he had jumped bail and is not in court to stand his trial. But they knew that their illegal actions made it impossible for the respondent to be in court for his trial. In a situation such as this one, where the prosecution has taken extrajudicial actions against the defendant in a pending criminal case brought by it, and made it impossible for the defendant who is on bail to be in court for his or her trial, it is wrong to treat such a defendant as having jumped bail in the sense that he is running from prosecution or running to avoid prosecution in the pending criminal case in respect of which he was granted bail. The respondent did not intentionally and knowingly fail to appear in court. It was therefore wrong and malicious for the appellant that had caused the respondent to flee from his home and country to secure his life, and that had therefore caused his unavoidable absence from court, to inform and thereby deceive the trial court that the respondent had jumped bail. On the basis of this deception, the appellant applied to the trial court for an order revoking the respondent's bail, forfeiting the amount securing the bail bond of his sureties, and an order issuing a bench warrant for his arrest. It is glaring from the record of the proceedings in the trial court that it granted the said orders prayed for by the appellant with knowledge of the fact that the respondent's absence from court was caused by the invasion of his home by army officers of the appellant. Therefore, the trial court knew that the said extrajudicial and illegal actions of the appellant made it impossible for the respondent to be in court for his trial, that the respondent's absence is not intentional or deliberate absence, and that the respondent is not running from prosecution or running to avoid prosecution. In the light of the foregoing, the trial court acted unfairly and without rational and legal justifiable basis by its decisions revoking the respondent's bail, forfeiting the amount securing the bail bond of his sureties, and its order issuing a bench warrant for his arrest. The orders were made on the basis of the false assumption that the respondent jumped bail. It was on the basis of the order of arrest of the respondent obtained under the false pretense that he jumped bail that his extradition or rendition from Kenya was carried out, per Emmanuel Akame Ajim, JSC, at pages 10 to 13. 3. In addition to the above, there is a lot more of what the Supreme Court had said against the revocation of Kanu's bail, and the consequent issuance of the bench warrant that grandfathered his infamous extraordinary rendition. To learn more, please pay some attention to pages 18 to 20 of the attached judgment. 4. It is on basis of this pronouncement that we made a vigorous submission on April 17 that the Federal High Court is bound to restore Kanu's bail, as demanded by the Constitution at Section 287(1) is thus. The decisions of the Supreme Court shall be enforced in any part of the Federation by all authorities and persons, and by courts with subordinate jurisdiction to that of the Supreme Court. 5. We further advance the common sense argument that bail restoration is the next best alternative that will enhance the environment for the accelerated trial the court had ordered, because it will put an end to the stringent DSS detention conditions which have posed grave risks to Kanu's fair trial rights as guaranteed under the Constitution. 6. For good measure, we stress the point to the court that it is against the ethics of the legal profession for any lawyer to advise a client to succumb to trial whilst his detention conditions are not conducive to his constitutional right to unhindered access to counsel and the adequate facility to prepare his defense. It is even more egregious in the case of Mazzi Nnamdi Kanu, because most of the charges he is facing carry the death penalty. The foregoing is a summary of the case in chief we had presented in court on April 17, 2024. We never presented any conditions. We don't even fancy ourselves possessing the slightest coercive wherewithal to present conditions to the court or the Nigerian state. Thank you. Signed, Aloy Edgemaker, ESQ.
Economy Nigeria. Yewo nenu osikano. Yewo alele kanebe. Alili ebuomu nenu wamo. Eziokwu na ndị ọcha pịawala anyị azụ. Eziokwu na ndị ọcha mela anyị ibe. Banyela ya ụka nye ndị ugwu ọchịchị nụ. Ma tata na anyị na-atụzi alele. Eziokwu na Chukwu ka na-ekwu okwu nụ. Emezia na mmeri bụ nke anyị. Chukwu ka na-ekwu okwu. n'igwe na-ekwu Chukwu ka na-ekwu okwu I see freedom coming freedom na-abịa mmeli na-abịa eziokwu na mmeli na-abịa na ndị Kanu ọchịagha ụmụ Biafra odogwu ndị Mozi na-agba ọzọ Igbo ndụ ezi Igbo gburugburu ezoghị na mekeneyi ndụ gị ga-adị ndụ gị ga-adị ezoghị
83% said sometimes.
Yeah, listen carefully, because this is the thing. The whole world is watching. Like Sora said at the beginning, we know all this, but it's now that is across board. People are speaking out. The ill treatment that meted to the Igbo extraction in Biafra land, and Biafrans at large, it's not just the Igbo extraction, because at the end of the day, even our kit and kins are getting 13% of their own resources. I never had such a thing in any country. But as we're still waiting here in the studio to get the final on-spot account from our reporter down there in Federal High Court, Abuja, I just pay attention to this. They call it peace in the Southeast and challenging and the solutions. At the end of the day, but only solution they're going to have is to, make sure that Mazi is being given to have his fundamental right. He's not running away from their so-called trial. Because before you try a man that you violated his right, you have to visit that force before the trial will commence.
Or always, they were treated unfairly by the government. This is last year. This is the highest rate of any ethnic group surveyed in Africa. In their view, they are sometimes or always treated unfairly by the government.
So is the issue of injustice?
It is a deep grievance, and it's a disconnect from the Nigeria project, as was mentioned earlier. And I mentioned that number just to underscore the underlying grievance that has to be addressed. So amnesty is potentially part of a package, but the disconnect has to be addressed, and the Southeast is a core pillar of the Nigeria project. It comes back to the discussion of its importance. So all of these issues that are being discussed are inherently political. They're being seen through a political lens. For example, infrastructure development. The grievance is you have a very productive region that is exporting not just to Nigeria, but internationally. You have, I think, Imo and Anambra are number 4 and number 6 for GDP in Nigeria. And that was in 2021, which was a very violent year. So even amidst the violence, three of the 5 states in Southeast are in the top 12 for GDP per capita. Yet there's no seaport. The bridges are not good. The roads are not good. So it is a development and infrastructure issue, but it's seen through a political lens as a political grievance. The same with security, which is you have significant deployment of security forces, yet the perception is the DPOs are not from Southeast. Many of the officers are not from Southeast. They are not necessarily well-versed in the local context. And so they're not performing the role of community security in a way that they or other communities would expect. So that's a security issue, yes, but it's also perceived through a political lens. And it's the same with federal appointments and involvement in governance. So these are development, these are policy, these are economic issues, but they're seen through a broader political lens that they're not being kind of fairly adjudicated. And I think that's really important to underscore. So amnesty as part of a package may be a solution, but the underlying grievances have to be addressed with an understanding of the political perception, how the infrastructure problems, how the economic problems, how the security issues are perceived politically, and what it means to have a more representative involvement in those efforts from a Southeast perspective. Yes, it has to be a multi-stakeholder approach. The sensitive issues have to be addressed, and there needs to be involvement of the key stakeholders as this initiative is doing. That being said, in contexts like this, you might not move everybody over. You might not convince everybody. But where you make a serious effort and where you provide legitimate avenues, you will see a significant reduction in popular grievance that draws down support for extremism and makes it very difficult to operate. So a multi-stakeholder approach doesn't immediately solve all the problems, but it changes the trajectory, and it moves a lot of the public into using or trying to use the legitimate mechanisms again, as opposed to staying on the sidelines or even supporting extremist activity. So it's where you need to start, and it's the direction that you need to go.
Kanu or answerable to ECWA?
Well, I'll speak on what I know as of counsel. That might be limited knowledge. That might be all you need to know, and our viewers tonight. Mazzi is the supreme leader of the indigenous people of Biafra. There are no two supreme leaders, and at this moment, there is no deputy leader. They have other leaders lower down the hierarchy of supreme leader and deputy leader.
eziokwu na alili na-egbu ụmụnne m na alili na-apịawa mazụ onye Igbo wee gụsị akwụkwọ nụ na inweta.
Today, we do not want to call it a travesty of justice because of the respect we had for the judiciary, but we are utterly disappointed that today bail was refused. On what grounds? The Supreme Court on 15 December criticized very severely the revocation of Mazi in several pages, which we are going to make available to the media. At pages 19, 20, and 21 of Justice Agem's judgment, he even suggested that the impartiality of the trial court in revoking Nnamdi Kanu's bail is suspect. We didn't mind all of that, but see, we made an application, a fresh application, to my Lord, urging her to exercise discretion to restore Nnamdi Kanu's bail. She refused it without any reason whatsoever. And then we made a second application to accentuate the need for this bail application, pointing to the enormous challenges we face as defense counsel in consulting with Nnamdi Kanu privately and confidentially at the detention facility of the DSS headquarters in Abuja. We are only allowed 30 minutes each as counsel on only Mondays and Thursdays for a cumulative period of 2 hours, twice a week, to consult with him separately. And the federal government is feasting to have an accelerated trial. Yes, we too want an accelerated trial, but we have to have it under an environment that respects Section 36, sub 6, B and C of the Nigerian Constitution. It's all about fair hearing. It goes to the ground norm. It goes to the basic norms of the society that you must hear the other side. And to hear the other side, he has to have an adequate facility to prepare his defense and to consult with his lawyers. It's the Constitution that said it. It's not us that said it. So we came to my Lord with an application and said, listen, it's impossible for us to conduct this trial under this atmosphere of interference with his right to counsel. They eavesdrop on our conversations. In the little cubicle room of 10 by 10 where we consult with Mazi Nnamdi Kanu, they have secret listening devices and secret photographic and videographic devices, they listen to our conversations secretly, they take our secret photographs, and we adduce this evidence before my Lord. They confiscate our legal documents. They don't allow us to take notes. Pray. You may be lay men and lay women. The general public may not be lawyers, but is this fair? How can you have trial under circumstances like this? It's not possible. So we are not stalling. It is the federal government that is stalling. We can't take notes. So what is the essence of it? We cannot prepare him adequately. We cannot talk with him. We whisper. We put our lips to his ear. We talk sotto voice, and so on and so forth. So this is the essence. This is what happened in court today.
Can you hear me now?
Where justice was turned upside down when our 2 applications that go to fair hearing were refused. But we are going to bounce back. There are more applications to come.
Are you going to appeal on this?
Yeah, definitely. Appeal is ongoing as I speak. Today, by tomorrow, appeal is filed.
Okay, excuse me. Please, in addition to that, yes. Please. Yes. In addition to that, what happened today is an act of Federal High Court overruling the decision of the Supreme Court. I want you to get it right. Because the Supreme Court said Nnamdi Kanu never jumped bail, that the court ought not have revoked that bail on the application of the violator of his right, that is the federal government. You cannot benefit from your own wrong. And we thought that the Supreme Court would have exercised its power under Section 6 of the Constitution to make a consequential order directing that Nnamdi Kanu should be released. But they directed that the trial should be continued here, and we should make an application. Of course, we ought not have made any application. Court should have exercised his power discretionary and released Nnamdi Kanu. That they never did. Then, secondly, which is the most fundamental, I had been going there to visit Nnamdi Kanu. They never allowed me to exercise my right as counsel to Nnamdi Kanu. And my right was violated. I took DSSS to Federal High Court. Federal High Court warned DSSS, ordered them to apologize to me, and ordered that they should pay me 5 million naira for close to 2 years now. They have not paid that money, and though I just allow it, that's why I have not enforced it, because 70% is running on top of it. Nobody has appealed against it. So now we filed the same application before the court. It's in the court file, asking my Lord to prove that we are not free. Where court has even taken judicial notice of that, but all to no avail. Now the court said that we should apply, since we cannot transfer Nnamdi Kanu to Kuje prison, stating that there is no security at Kuje prison. So that we are now applying that Nnamdi Kanu should be detained, should be remanded in a private house. And we are suggesting Abia State Government House or Abia State Liaison Office. So that is the application. So that is it.
I want to thank the press, for keeping the struggle alive. Yes. Now, I must tell us something. What happened today in this court is almost like an opportunity lost to bring peace, immediate peace, to the southeast. The Supreme Court had given the Federal High Court the opportunity to bring peace to the southeast.
And they lost it.
And unfortunately, they are toying with that opportunity given to them by the Supreme Court. All that the Federal High Court need was to go back to the ruling of the Supreme Court and follow it and give back the bill it had previously withdrawn. And then you will see absolute peace in the southeast. But with what happened today, it's obvious that certain persons don't want that peace to return to the southeast. And we are imploring members of the public to please continue to interrogate the reason why the Supreme Court judgment of 15 December 2023 will not be complied with by a Federal High Court. We need the Federal High Court to simply obey the orders of the Superior Court. A court, look, you did not employ the judges of the Supreme Court for the sake of employing them. Whatever word they utter from their mouth touches on something fundamental. And in this case, in other circumstances, what is fundamental is Nnamdi Kanu did not jump bail. You have no reason to have revoked his bail. Restore it. And the Federal High Court is kind of toying and playing around with it, thereby continuing to create the chaos in the Southeast, thereby continuing to make the federal government waste money. Do you know how much the federal government is spending every day? Nnamdi Kanu coming. They told us they spend 500 million naira. Somebody is signing off that check. Somebody is signing it off. Who is signing off? Who is making money from it? Extra allowances are being paid to all the security men who are in Abuja because of Nnamdi Kanu. It's your money. And we have been saying the case of Nnamdi Kanu is not such that we need to spend scarce resources on. The federal government is caring about money. They don't have money, but they have all the money to pay all the security agencies. If you go outside, not less than 1,000 security agencies are on patrol in Abuja because of one single man. And tomorrow they will tell us they don't have money to pay salary of workers. So we need them to be reasonable. We need them to do the right thing. We need them to do the proper thing. Thank you very much.
It is better, they have a better facility. The prison, the correctional center people does not have any real interest in this matter, like the DSS would have. You know, the DSS and the National Intelligence Agencies were the ones who went to Kenya to rendition of Mazi and Nnamdi Kanu. They are also part of the team, the military team that invaded his house and tried to kill him, where they killed about 28 human beings. So with all these things happening, how can you be comfortable in their custody? You know, being in their custody is like, you know, is like somebody who raped you. You take the rape victim to him and say, keep. You understand what I mean? It is like keeping the rape victim with a rapist. It does not make sense. It does not give room for justice at all. So that is the situation. Yes. So now the court has given us, they gave us a date for hearing, being the 19th and the 20th. So we are going to study and consult the Mazi Nnamdi Kanu, the next step to take. We already have one or two ideas in our mind, but we need him to confirm those steps. If he confirms those steps, then we can take those steps and make sure that he gets justice. All we are looking for is justice, as simple as fair hearing. That is all. And without fair hearing, anything you do here is nonsense. So we want the courts of Nigeria to respect fair hearing. We want the Ministry of Justice to respect fair hearing. We want the federal government of Nigeria to respect fair hearing. That is why we are hammering on it. It has taken us over throughout this year. We have been battling the issue of fair hearing throughout this year, and you know, they make it look as if it is Nnamdi Kanu's lawyer that are not ready for hearing. But you make it impossible for us to be ready for hearing, because for you to allow us to have the capacity to do a fair hearing, give us all that is required. Give us space. Let us talk with our client in confidentiality. Stop listening to our discussion. Stop videoing us when we are talking to our clients. So those are the things we are asking. They are simple as that. But the federal government, because they are determined to see that Nnamdi Kanu is jailed, that is why they are also determined to make sure we don't get the fair hearing. And we are determined to fight it to the last man standing. That is the thing. Yes.
But I understand that one of the laws of natural justice just put forward fair hearing.
Yes.
And not being a judge in your own
case. Yes.
Okay. And all of those points out to the insubordination you quote of the Federal High Court to the Supreme Court.
Yes.
Because, according to the Supreme Court's ruling on 15th of December 2023,
yes,
which is made public, everyone has a copy, more or less.
Yes.
Courts, the SC, the Apex Court says restore Mazi Nnamdi Kanu's bail. And the Federal High Court in question is not adhering to that. We want to know, is there any sort of penalty imposed to that very,
well, you know, there's what you call judicial rascality, where an inferior court decides to disobey or disregard the orders or directives of a superior court. It is called judicial rascality. And so many times judges have been penalized for it. Recently, just last week, so many judges were issued warning letters. Some of them who ought to have been promoted to the Court of Appeal were denied that promotion because of their rascality in the High Court. So there are penalties, there are consequences for disobeying the superior courts. But in this case, I don't think it is right for me now to say these are the penalty, because I'm not the one who is going to dish out the penalty.
But we'll make our complaints to the appropriate quarters. And it is for the appropriate quarters to decide whether they want to penalize or not. But we, on our own part, will do what is required of us by our client.
Okay.
Yes.
One more technical question. The public is in the know, at least with the health system of the defender.
Yes.
Question Mazi Namdekano. How is Mazi Namdekano?
His health is deteriorating. We did another letter 3 days ago to the Directorate of States, that's the SSS, to help him with his ear. Mazi Namdekano does not sleep at night because, according to him, he has this noise inside his ear as if there's a cricket, a whistling sound inside his ear. So it does not allow him to sleep. And the doctors have prescribed what they call transistor radio. It's a kind of earpiece you put in your ear. Maybe it will give you some rhythmic sound to make you sleep. He has applied for it. He has begged them to give it to him. They have refused. We have done another letter just 2 or 3 days ago to the state services to provide it. Or if they cannot provide it, then let them allow IPOB members or IPOB as an organization to provide it to their client, or allow the family of Mazi Namdekano to provide it. They have refused to take anything from the family, anything from the lawyers, anything from anybody for Mazi Namdekano, and yet they themselves have been incapable of providing this needed facility. So you can imagine where a man is sleepless for 3 years plus going. He doesn't sleep at night. That noise, that wing rings in his ears steadily. So at night, he finds it very difficult to catch a sleep. Then not talk of the heart issue. Of course, you know Nigeria. If you are being asked to do a heart surgery in Nigeria, you might say no. Take me to Canada or somewhere where you are sure of basic health facility. But in this case, Mazi Namdekano is battling with his heart issue. Doctors have come and recommended surgery. Even the doctors of the state security services have recommended a heart surgery for him. But up till now, how many years gone? They have not been able to provide it. And you know, every day that goes, every day that passes, you are dying gradually. Every day that passes, you are dying gradually. So Mazi Namdekano is dying gradually, health-wise. So that is the situation. And the DSS knows this. The federal government knows this. But they have deliberately refused to take serious steps towards it because they want, that is the result they are looking for. That is the result they are begging for, that he should die. Or that when they are very, very sure that he's now quarter to die, they may release him and say, go. Then after 2 months, yeah, he passed away. That is what they are thinking. That is what they are planning. So that's the situation now.
We learned 19th of June is the next adjourned day. What
Yes.
is the business of the said day?
Well, the court adjourned it for hearing. The prosecutors say they are ready to call their witnesses. On our own part, we need to discuss with our clients, considering the ruling of today, to know the next step to take. If it's to go into the hearing, we can go into the hearing, depending on our conversation with our clients. If it's to do other things, then we can make options.
Speaking about hearing the substantive trial.
Yes, the substantive trial, they will call witnesses, we will testify, we will ask questions.
That's okay.
Yes.
Let's see how it goes.
Thank you.
Thank you very much.
Thank you. Thank you very much.
Thank you.
Thank you. You're welcome.
Very sad. Thank you so much. Very sad. Very sad. Very sad.
Thank you very much. We appreciate every one of you. That was the voice of one of us, Barrister Nemeke Ejiofor from the Federal High Court. I believe we have heard what transpired in court. Basically, Mazi Namdekano was denied restoration of bail, and as well the non-custodial arrangement to, putting him to a house arrest. It's very sad indeed, and what is left of us is to pursue and to make sure that fair hearing, that the laws of natural justice is being adhered. Funny enough, these very laws and constitutions and everything we are quoting is of the land. So it is ironic, I must say, but we are our eyes are fixed on the ball. What they want is to incarcerate
Yeah, Maz, your intermittency, I know, is the epileptic, The zoo epileptic.
So,
So, yeah, we are off for like 30 seconds. Okay, I think we lost him there. Everybody has heard what President Nemeke Joffo narrated, what happened in courts, and concerning our leaders' health, like we rightly said, regardless whatever they are planning, Bintan Yeko is playing on the script. We know that. So it is not something we are not aware of, but that will not go into details. So, like they said, substantial trial, they say 19 to 20 June. Yeah, like Nemeka likely said, everything boils down to our leader and Bintan Yako and whatnot they should have said. Onyendu need to have a conducive place to actually to communicate with his legal team. I think that's the main thing, fair trial. We've done through this process before. And now they have brought the same pattern. They have not got any other thing to add in what they have done before. So it is not something that come to us unaware. We are aware on all their metaphor, the way they operate, their modus of operating. We are aware of it, but it's entirely up to us now to brace up, and everybody needs to, all hands must be on deck as going forward, as Nemeka rightly said, until our leader gives his own words, because he is one that have the final say. He is going to make the decision if they're going to go forward or not. So yeah, I think I need to give Lawman a chance, see if he can come back. Lawman, can you still hear me? Because you were rightly like gone off for 31 minutes.
yes, Mazi, Umeh, we are still here live and direct. I believe we have just heard what transpired in court today, and as well what would happen in the next adjourned date on the 19th of June. As a matter of fact, this is a case of Ojoyena Lajionwea, because if you ask me, that's an adage in Igbo, one who apparently holds their enemy is on the ground as well. Because if really, let's just assume from a general point of view, they want to jail Nnamdi Kanu, they should, allow a window for fair hearing so that this said prosecution would happen quickly and they might jail him. Let's just put it that way from a general point of view. But they know what they are doing. They don't want to pursue the trial, because they know at the end of the day they don't have anything against this man. Do you understand? So we are fed up. We are fed up very much indeed. So the court now has refused the both application and even asked the defense team to proceed to appeal. So that is the situation report, and that is it. You heard when the briefing was being given regarding his health, which is one of the important causes of standing trial, because for one to stand trial, they need to be healthy. Mazi Nnamdi Kanu's health by day is deteriorating, and they don't want to care. So the defense team is trying their best to ensure that Mazi Nnamdi Kanu's, if would be, available for trial, it must be on the basis of natural justice. So that is what transpired in case in court today in a nutshell. Do you have any question from your stable, please?
Mazzi, what can I say? I was just like talking before you come back. I had everything Nemeka said, and I can't thank you enough. There's nothing really to talk about right now. Like I said, we need to go back to the drawing board. We all know that we've gone through this phase before. It's a delay tactics. They're holding themselves. And like you said, we remember 2016, secret trial came up. Remember the days of secret trial? And now they want to commence the substantial trial without any background. Because at the end of the day, to you to start this trial, extraordinary rendition is what is supposed to deal with before coming to try a man that escaped death. But like you said, all these things we know that the people that are behind all this, the people that are writing this script are Britain. This is where we are right now, where I live. So And our leader, to be honest with you, is equal to the tax, and Biafra at large. All we have to do is to keep focus, our eyes on the ball, like you rightly said, and wait for the next calls for our legal team. As our barrister Nemeka said, that they have to go back to our leader to get a clear view on their way, because if they're going to honor that very 19th to 20th for substantial trial because of they didn't grant that, they didn't restore our leader's bail, and or even as what they rightly said before, to find a place. Remember that Anambra State Governor offered Onyendu to be on house arrest on Oka, and they refused it. So there's windows for them to do things, but those that are benefiting from this, that's why they held in our leader. So Mazi, lawman, I think we all have done wonderfully, and there's no more question to add on what you have said. So I think today is another sad day, but what it is that the more the day as they go by, they expose what the evil they have called to them themselves. Because Biafran, we're asking for one thing: is equity, fairness, and justice. That's what we're asking for. So Mazi, I think that's all I have for you. If you want to add more, then you go on before we call it a day, please. Mazi, can you hear me?
Yeah, yes, very well. I can hear you. Never knew my microphone was muted.
Okay. Yeah. So there's no more. If there's anything you want to add or say, say our last word to the Biafrans before you leave the studio, so I could just close the program.
Yeah. The very important thing is that we are always ready. We are not running away from this very case. Rather, they are the one running away from their own court. So we must be focused. They want to cause distraction, or even they want to cause us to, make protests, to make troubles, or even to cause, in quote, unrest, so that they would, take away what's on the table and start saying another thing. So let's just be focused and eyes on the ball. That is it from now, from me.
Thank you, Mazi. Thank you, Mazi. And that is our lawman down there in Abuja, our reporter from Abuja. Thank you, and remain blessed. Fellow comrades and lovers of freedom, and this is still Biafra Radio, and this is the junction. We're going to close the curtain today. Today is another complicated, I must say, but to be honest, every IPOB member that are Biafran that are close to what we do, we understand that we're not expecting anything better than what we've just heard, because we know that everything that have happened is a script and it's state managed, but they cannot run away from their own shadow. Regardless, our leaders felt we have heard it, but one thing we know that Chukwuabiama will continue to do what makes him, he called him, he will protect him. At the end of this, what we can take out of this is Mandela spent 27 years in prison. And not on this era that we know. Then there was communication blockade. Let alone now social media is there. We can force out what is happening around us. So no one should be deterred of being in this position. If Onyendu, like those that told them to kill our leader, from Kenya to Zoo, it is too late, they wouldn't do that. The same way Chukwuabiama rescued Daniel from the lion den, the same way Mazi Nanikano was rescued. And the end is bright. At the end of the day, they will come to that court. We will defeat them in that court, like Onyendi said. And I can't thank all of you that have taken out your time. And today again is a wonderful day. And we didn't say it's sad, because Onyendi have spoken. I saw a couple of videos Onyendi have said things. So let's brace up and equal to the task. Everybody must do what he's been asked to do. So from me, from here, it is good afternoon from London.